$2,000.
There we go.
All right, motions on the floor to change books, publications, subscriptions from 7,000 to 1,000. It's been moved and seconded. All in favor, say aye. And then have a contingency bouncing up at 322 that we moved up top. So take the 32200 contingency out. Miscellaneous expenses, 3,000. Oh, I'm sorry, all of those. Miscellaneous expenses.
Zero.
Motions on the floor to change miscellaneous expenses from 3,000 to 0.
So moved.
The second, all in favor, say aye. All opposed? Record, who seconded it?
No, I didn't do. Oh, no, absolutely.
I moved.
Yeah, that, I care as he did.
Capital olays, do we know what that is, 259, 798?
As it says, capital outlays, again, I will confirm, but it's, I don't think that they would want to purchase more land or something like that.
So I move that we take that out of the budget until we get further information, and we can always come back in a meeting.
All right, so capital outlays is a well, $259
$259,798.
to remove it for now until we get further information.
Zero.
Zero.
Two, yes.
The motion is on the floor.
Yes.
It's been moved second. It's been moved in second. All in favor, say aye.
All right.
All opposed?
We need clarity on who moved it. Who seconded it. 7 people moved it. 7 people seconded.
Director, oh, I'm sorry, Director Henderson moved it, and which one? Wait a second.
Boardroom random.
Ms. Rand. Director, did you say? Director,
Yes, yes, second.
and that beats the budget, but now we need to close out the entire motion of the budget. So it was already moved and seconded for discussion. So the motion now is to accept the budget with all of the sub-motions as stated, amendments as stated.
So
That was opposite what we just did, but it's been moved and seconded. All in favor?
Aye.
Aye, all opposed. That concludes the approval of our fiscal year 2022-23 budget. I move that this meeting be adjourned. All right, it's been moved. Is there a second? Second. It's been moved and second. All in favor, say aye. All opposed. I'll go recess for about 5 minutes and start our workshop.
Okay. You should have heard it go down. She should be prepared to come in here. Okay. Yeah. Thank you.
I think we'll just start about 2 to 3 minutes. So while we're waiting, please remain silent or put your phones on vibrate. I would appreciate it. Also, if you want to speak, please be reminded that the forms are over to the side for citizen participation prior to the 7th.
Oh, I'll tell them. Use the arrows. The arrow right here. The arrow. Okay. When my time comes, I know how to do it. As long as it's up there. Now, if it's pulled up there, it's a different story. But if it's up there, I can get the arrow.
This can be ready. The time is 6:45. We're now opening up the town council workshop for the town of Eatonville. And on the agenda, the first item on the agenda is discussion on public records request on the Florida statutes. Council.
That's my psychological skills here. All right. Hopefully everybody can hear me. This is a presentation I've given literally dozens of times all over the state of Florida. It usually comes in a package of 4 hours. I know y'all would love that tonight, but I'm just not going to do it. Instead, I'm gonna try to keep it to 30 to 45 minutes of questions and cover the stuff that y'all need to know, in my opinion. And I'm hoping the staff is here for the staff that needs to know, because that's gonna be as important as whatever I tell you. But as you all know, as elected officials, you guys are required to have training that doesn't apply to everybody else for ethical training for municipal officials. It includes sunshine law. It includes 1 hour of sunshine law, 1 hour of public records, and 2 hours of ethics. And this is the hour, would be ordinarily the hour that involves public records. The reason this is important and the reason I came to give this tonight is because Mrs. King and by extension me have experienced problems in timely complying with requests. And so my goal tonight is to some degree to provide the motivation necessary for everybody to understand why, as a group, we need to do better. So let me start by saying that the public records law was designed, Chapter 119 of Florida statutes, to perpetuate, communicate, and formalize anything that involves public business. And so if whatever the record is we're going to talk about, and it can be something, it can be emails, it can be actual records like bank statements and so forth, it can be notes passed in a meeting, it can be any kind of thing, but it involves the public's business, it's a public record, subject to a very limited set of exceptions that have to be applied if they are applicable to the situation. The reason it's important to understand that that definition applies here is because there are a number of things I'm certain because of what I've already seen here, and I hate to give you guys my back because I kind of look this way, but I am intending to talk to you as well. It is because I know almost assuredly that things that are public record are not being treated in the appropriate way by folks. And so we want to solve that problem before we have an embarrassing situation. Now, something you may not know is that this public records issue isn't just a records issue from the statutes. It comes right out of the Florida Constitution. And it says that every person has the right to inspect, copy any public record made or received in connection with the official business of any public body. Let me stop right there and say, official business does not mean it has to come to the city hall. If you receive an email on your personal email, but it's about city business, that's a public record if you're an elected official or an appointed official. That is what it is. And so that may be a stumbling block for some people. Oh, that my records don't matter. No, they absolutely do because of the position that you hold. And so whether it's they come to you or employees acting on your behalf, unless they're exempt, they're public records, and that's really important. Okay. So why this constitutional provision is in here is as a reminder that all of you take an oath of office. Appointed boards don't, but you guys do, that says, I will obey the constitutional laws of the state of Florida. So if you disobey, intentionally or not, the public records law, you're violating the Constitution. That's important to get. Okay. Policy for the state of Florida, which is stated in 119, the statute that embodies the Constitution, is that it's the policy of the state, county, and municipal records are open for personal inspection and copying by any person. Providing access to public records is the duty of each agency. Okay. Now, that gets a particular focus here because when it says any person, it literally means any person. It doesn't mean just the citizens of Eatonville. It means that somebody who just walked in from another country or New York or any other state does not matter, and they do not have to identify themselves. If they come here looking for records, they're entitled to them as a matter of Florida law. And this is important, if you have the records, if these records that are public because they deal with official business of the city, and you are an employee of the city, you are an elected official of the city, you are an appointed board member of the city, if you fall into any of those categories and you have a record, if you haven't provided it to the clerk, so she can then respond to the records request, you now become the custodian of the record. And every criminal penalty you're going to hear me talk about tonight now applies to you personally, which is why you're going to hear me advocate to make sure that you turn over all those records to the clerk so you stay out of that mess. Every person who has custody of a public record shall permit the record to be inspected and copied by any person desiring to do so at any reasonable time, under reasonable conditions, and under the supervision by the custodian of public records. In this case, that would be Ms. King for us, okay? And if those records have not been provided to Ms. King, she cannot comply with the request. And by not providing them in a timely manner, you have become the custodian. So now that liability goes directly to you. Okay, that's important from a staff perspective, that y'all understand that when she sends out these emails saying, I need the records, it's protecting her, but it's also protecting you if you provide them. And if you don't, consequences can happen. Do you have custody? Do you have it on a phone, a piece of paper, in the mailbox, wherever you got? If you have it, your job is to produce it. So what do we recommend? Transfer the custody to the clerk so that we don't have to go through the how many weeks have been waiting. We're not supposed to be waiting weeks to comply with public records requests. Hours in many cases and days at the most, not weeks, not weeks. Okay. Now the custodian of records, in this case, our clerk typically has to acknowledge the request and inspect and copy records promptly and respond to such requests in good faith. This is an important thing, and I actually think that Ms. King does a very good job on this, because I had not seen anyone else do this. So I think it's very novel. I know this because I've gotten, when she was on vacation, bounce back of emails that said, I'm on vacation, or I'm out of the office. But if this is a records request, meaning you sent me an email records request, I am acknowledging you in this email that we got it. That's brilliant, because if she's gone for a week or 2 weeks, that immediate response and acknowledgement is still met as soon as the email hits her box. So that's really a good thing. And that's one of the very novel things that I will now incorporate when I teach this lesson to other people around the state of Florida. But that's a very good thing. But there's a reason. She's not doing that out of the goodness of her heart. This is statutorily required, and that's where that requirement comes from. Okay. Acknowledge the request promptly. And if you didn't give the records to her, it's your duty to acknowledge the request promptly. Okay. If there's an exemption that applies, and there is a ton of them, and I say a ton of them, they're complicated and they cover everything from confidential services for law enforcement, ongoing criminal investigation records, certain kinds of personnel records, certain records that would be covered by HIPAA type of exceptions, social security numbers, bank account numbers. One of the ones that would be maybe surprise you, a photograph of a firefighter. That's not a public, that's exempt. And on and on. So if you don't know those walking around, then you could have a problem. Why do you have a problem? Obviously, if you produce the record, you say, well, at least they got the record. The exemption isn't for the town. It's not for the town. It's to protect an individual privacy issue or something that the legislatures declared to be important enough to protect. So we don't have the option of not asserting it. This is why you really have to understand this stuff. You must assert it, because you're not protecting you. You're protecting somebody else's information. So if your initial response is, oh, they want all my emails, here you go, and you haven't looked at them and something in there is exempt, you created a different problem. And that's why this stuff is so important to understand. And so exemptions are not optional when they actually apply, just not frequently, but there are a lot of them. They must be asserted, and the document has to be not redacted, where you black out certain portions of it, and so that it can't be seen, like if it included an account number or somebody's phone number who happens to be in the police department or whatever else, things like that have to be taken out. That's how you do that. And you then produce the remainder of the record, but you take out the privilege part. If portions are exempt, you redact and still produce. The issues, if the record is exempt, that's one thing, or confidential, that's a different thing, or both. What's the difference between exempt and confidential? Well, exempt is like the things that I told you, where we're talking about taking out certain portions, like if there's a social security number, if there's a photograph of a law enforcement or a police officer or an address of their home, something along those lines. A confidential record is one where the entire record is deemed confidential, something like a mental health record, okay? We don't talk about, not only, it's not, oh, you can get the name, but you don't get to see what the diagnosis, you don't get any of that. So there's a distinction, and you have to know the distinctions, okay? If you contend that a portion of the record is exempt from inspection when you provide the response, and again, if it's Mrs. King, what she has to do, she has to say, these portions are exempt based on 119.01 sub 6, sub 5, whatever the various exemption is that applies, or some other statute. And it has to say, you can't just send a record with certain parts blacked out without saying, here's why they're blacked out. So you have to do both things. And again, if you haven't produced the records to her, then you have to do it. If the person who's requesting the record is seeking to inspect it is a custodian of public records, has to state in writing the reasons for the conclusion that the record is exempt or confidential. Like I said, you cite the statute, state the basis, and give the reasons. This is important, and it must be done in writing. You can't just tell somebody at the counter, we struck this out, because you have to put it in writing. Okay, the custodian of record shall furnish a copy or a certified copy upon payment of fees as prescribed by law. If fee is prescribed by law, not prescribed by law, the following fees are authorized. You can furnish the copy. You have to do, you can collect in advance for deposit if it's going to be a massive production of many, many pages of copies, or a lot of office time to go through and insert the exemptions. You basically determine what is the lowest paid person who is qualified. That's critical, not just the lowest paid person, but the person who is qualified to go through, look at the record, mark out the parts that need to be marked out, apply that hourly rate to a rough estimate of how long you think it's going to take them to go through the records. And then you say, okay, based on our assertion, it's going to take 3 hours at $25 an hour for each those hours. So we need $75 in advance. Then you can hold on until they give you the deposit to actually begin putting the records together and marking them up and provide it. If you takes more than the amount that you deposited, or you ask for the deposit, then you can charge them for the balance when they come to pick them up. If it's less, then you refund the balance. But that's how that's done legally. Okay. That whole provision we just talked about comes from this policy about extensive use of information technology, clerical or supervisory systems. This is where you can put that special service charge that we just talked about, based on the lowest paid person who is capable of making that determination as to the records that are being sought. The duty is to gather the documents for inspection, collect the special service fee in advance, so you're not stuck having done the work and then you never get paid. This is an important kind of pro tip. A lot of times when you say to the person, okay, well, based on this massive request, which covers 10 years, it's going to cost you, several $100s, they get more realistic about what they really want or really need. And that's not designed to dissuade them, but it will frequently cause them to either lose interest or narrow the request to a more reasonable request from a standpoint of time and ability to put the stuff together. But that's why you want to tell them in advance what it's going to cost. Okay. Critical here is the words regardless of the physical form. So many times we are confronted with things that we don't think of as records that are public. Well, let me give you some examples that you might have not have thought of before today. I don't know who here has Facebook, but if you do and you have comments on your Facebook in a professional capacity as an elected official of the town or as a board member, and somebody comes onto your Facebook page and says, I really didn't like that project you approved, or I really thought that was a great idea, or whatever they may say, they're transacting business with you in an official capacity for the public to see. And therefore, if I come in and say, I want all the comments off of your Facebook page that deal with business, you have to provide it. Why is that a problem? Well, because Facebook has this little feature that says you can delete comments. But the fact that the writer can delete the comment doesn't mean you're not responsible for finding it. So you need to find a way to preserve comments on your stuff that are related to public records. Whether that means screenshotting them, finding out, I don't know if there's somebody in an IT who can walk you through a process by which they're automatically saved, because sometimes, me included, I'll think better of something after I posted it and think I should take that away. But it's still a record. And you're still responsible. The person who wrote it, unless they happen to also be an employee or something, they're not going to have a problem, but you're going to have a problem. So that's important to understand. Okay. Now, there's plenty of case law that covers this subject, and trust me when I tell you, there's many people trying to figure out how to avoid the application of this law. And that's one of the reasons why I had 3 cases that are relatively recent. There's tons of them, but I've got 4 recent ones because I wanted to show you the impacts of what happens when you don't do this. Because so many people just tend to think it's never going to happen to me. And I'm here to tell you it does and it will. Okay, the statutory test is the transaction of official business. Not every record is personal just because it's on a city computer. If, you know, some person on the city computer requests a recipe from somebody else, it's not record because it's not dealing with public business. It's not the location of the record on a business computer or a public computer that makes it public. It's what it contains. But here's the problem. In order for a court to determine whether it's a public record, the court has to review it in camera, which means essentially behind closed doors. But if you didn't want anybody to know that personal piece of information you were out working on the computer about, I got news for you. They're going to know because the public may not get it, but at least a judge somewhere is going to get a chance if there's a lawsuit brought to look at and determine. Why is that important? Because in this day and time, I know from personal experience of cities that I work for that people have done highly inappropriate things on a computer that were not public record. But in order to prove they weren't public record, they had to be provided to a court. And the person was not happy about that. So this is important to understand. Okay. Does it include political records? Yeah. What do I mean by political records? When y'all run for office, before you get in office, and everything that's happened, if you're not in office, those emails between you and your supporters, all that stuff, not a big deal. But let's suppose you run, and at the end of qualifying, you're unopposed. Anything that happens from that date forward, but even though you're not sworn in, you're immediately under some public records law right then. You're also under sunshine law right then. And what that means is if you have people who are zealous supporters of you and they're talking stuff about each other or other people and so forth, and then I come along and say, okay, I want all the emails you got since the day you became an official elect about anything having to do with city business. And it may be embarrassing, but I get them. And if I don't get them, here's where it gets hairy. Because there's always 2 people on one of these communications. As you're going to see in one of these articles, the reason they're able to find out is because if the official doesn't provide them or the employee doesn't provide them, usually the person who was on the outside looking in will, and when they do, then it's the other person who gets in trouble. That's why it's important to understand. Okay, so here's a life lesson to talk about, and that is Merlot and email do not mix. Now, all I can tell you is we've all done it. You get a little irritated, get a little upset, and you say, you know, I'm not going to tolerate that. You're going to start, and you get a little more free with your words. But from a public record standpoint, it's still a public record, no matter how embarrassing it is to you. You do not want to do that. Okay, so meeting notes. Let's talk about those. I don't know how many of you all take notes during meetings, but if you do, and you keep them to yourself, meaning you do not share them with another human that's on this body, they're yours. They're not public records, you're fine. As soon as you show them to the person next to you, pass them down, distribute them with the intention of picking up, they become a part of the decision-making process. They're not just used to prompt you, they're used to help make the decision, and they become public records. Why do I say that? I've been in multiple meetings where I've seen council people passing notes amongst themselves. My people, the one who I give this lecture to. And all it's going to take is somebody to come to the podium and say, I want that. That's a public record. Now, what it could be, and most of the time it is a record in which they're saying, hey, you know the score. We have meetings on Monday. You know the score of the Monday Night Football game? So it has nothing to do with it. But here's the thing. Do you really want to be outed for talking about Monday Night Football when you're up here doing business? Probably not. So not a good idea. Draft documents. Somebody said, well, they're drafts. Why does that matter? Well, because if the draft documents are distributed and comments are made and put back in so we can then revise the drafts, those drafts are also public records. Retention of records is important. But how does that work? Well, the Division of Library Services, which is under the Department of Administration of the state of Florida, they have a schedule, which Ms. King may be familiar with, but it basically goes through the categories of records, and it tells you if it's in this category, it's this long. If it's in this category, it's that long, and that tells you how long you have to keep records. But for most records, it's a while. It's not yesterday. Okay. The custodian has an obligation to retain the public records. This might be you, as we've said, Department of State Division of Library Services, what I said, where they get the schedule from. If you deposit the records with the clerk, then you have no problem. So what's this Schwab case? Why is that in here? Well, it's because you may not think of this, and organizations you work with may not think of it. I do not know, for example, I've heard the term ministry, and I know it's more than just an organization that's here. I know it's in other cities. I've heard it. I just don't understand all of how it works. But whether it's Main Street or any other business, particularly nonprofits, one of the things that has been determined by our Florida Supreme Court through this case called the Schwab case is that nonprofits that are doing essentially the job that we consider a city job, something that government would generally perform, can be subject to public records just like us. What's the key? Well, number one, how much of their money comes from the government? A good example for us in Maitland is the Maitland Library. It's a public library, but like 99% of its money comes from the Maitland coffers. It used to consider itself as a private library, not subject to sunshine, not subject to public records. Then they asked me to render an opinion, and I rained on their parade because of this case. Because there's 8 or 9 factors in the Schwab case. It's how much money do you get? Are you performing government function? Is there a mixing of accounts and various other things? Are you in a government facility, a government-owned facility? You know, in the case of the library, the answer is yes, and so on and so on. And at the end of the day, even your nonprofits that are doing community service that is something that you want and support, they need to understand they have the same liability for public records. And so that the more money you give them, the more likely it is they're going to have the same compliance issues that you have. Okay. It's a totality of factors is how they view it. If you ask me, money support is the biggest one, but there is no specific opinion in the AG's office or in cases that says this is the most important. They tell you they're equal, but based on the rulings that I've seen, money is the biggest one, but it's not the only one by any stretch. And basically, it's this person's acting on behalf. So people who are acting, essentially performing a government function in the place of the government. Okay, so what is the violation? And this will get into these cases in a minute. A public officer who violates any provision of this chapter commits a non-criminal offense punishable by a fine not exceeding $500. Okay, stop right there. Who is here can remember when the city of Orlando, or was it Orange County, maybe Orange County Commission, got in a big issue, it was the Orange County Commission, I remember now, regarding Disney and basically the theme parks and vacation and sick leave and making that a policy. All right. But if you don't remember the story, is that there were people out in the audience who were lobbyists, which means somebody who's getting paid to convince folks that are elected what to do. And they were texting the whole time they were discussing this potential legislation. And people who were in the media seeing everybody's on their phones, which everybody seems to do these days. And so after the meetings were done, I don't remember which way the vote went, but at any rate, they immediately requested copies of all the text to see what the lobbyist was trying to tell the folks up here making decisions while they were making the decision. At the end of the day, they all got charged. They all paid a $500 fine. Not one of them was exempt, and this is why. And they said it was not a knowing violation. I'm dubious about that. I think it was exactly what, but nevertheless, they got lucky because if you follow the next category, which is a knowingly violation of the statute, you're subject to suspension, removal, impeachment, and addition. You're guilty of a misdemeanor of the first degree. Punishable is provided. If you don't know what that is, up to a year in jail. Any of the provisions of this chapter commits misdemeanor first degree as provided in, and that's what it is. And there's another possibility. If you're doing it to hide something specific in furtherance of a crime, it's a felony in the third degree. Okay. You can go to jail for this. All right. Now, this is going to tie into the cases that I'm going to go over with you now. This is the Martin County situation, which you may be. I don't know these people. They may be wonderful people. That's not the point of the story. Okay. Both of them were charged with criminal violations of the Public Records Act. One of them worked their charges out, and the other one went to trial. Now, let me first point you to this case, which has this headline. It says, 2 Martin County commissioners, 1 former commissioner faced public records law trials in 2018. These are the 2 they're talking about. Let me read the highlighted portion for you and for everybody who's out there who hasn't seen this. It says, 2 Martin County commissioners and a former commissioner will face trial next year on charges they violated the state public records law. This was written in December of 2017. Their cases stem from the county's long-running civil lawsuit with Lake Point Restoration, rock quarry, and allegations that county commissioners destroyed or failed to produce emails pursuant or pertinent to the case. Now, here's the money talk. If you go to the second page, it says Lake Point and Martin County sued Martin County in 2013, claiming breach of contract and state public records law violations. As part of the suit, Lake Point asked Hurd, Fielding, and Scott, those were the commissioners who didn't comply with public records, at least 2 of them, received the personal mail accounts. The next line that's important. Martin County in November authorized settling the lawsuit for, hold your breath, $12 million, apologizing and an apology. When I tell you it's serious, I can't be any more realistic than that. It's serious, okay? Now, some of the next cases, which let's see what else we got in here. Lawsuits are no bargain, as we just talked about the 12 million. This is a Sarasota one. The suit asked a judge to grant an accelerated hearing in the case, declare that Barwin and the city, Barwin was the city manager only, violated the state record retention rules and the Sunshine Law, failed to produce city-related discussions from his private Gmail account as part of numerous public records requests, broke state open records law, and eroded public trust in local government. The 23-page lawsuit requests the judge to order Barwin and the city to follow the law, make records on Barwin's personal electric devices available for inspection, pay Barfield's legal fees, and award any other relief the court deems appropriate. Let's go back to the legal fees for just a minute. Something near and dear to my heart. The 2 ladies that were on that slide that I showed a minute ago, those 2, I don't know which one on the left, one on the right. One of those went to trial saying she was innocent. Here's the good news. The jury didn't find her guilty. Because they didn't find her guilty, she got to apply to the city for reimbursement. This is the same county who paid $12 million in a settlement. Anyone can guess what her legal fees were that she then got reimbursed? Almost $500,000 to defend herself, that then had to be reimbursed. So first out of her pocket, not easy, and then second, reimbursed out of the city's coffers. And the city, you don't get to say no. If it happens to one of you and you get off, the city is on the hook for that bill. And full stop. So it's an important thing to understand. And it's why I've been making a big deal about it. So let's look at these last 2 cases, all right? So Tampa launches investigation into whether council member violated ethics rules. Here are the keys from this one. A Tampa City Council member. This was March 16, 2022. It's pretty recent. Tampa City Council member resigned and apologized after he was sued for failing to comply with records requests. On this article, there's a great clip, but I couldn't figure out a way to put it into the thing. I would have liked to be able to push the button and play it for you because it's like a primer on all the things I'm talking to you within a news broadcast, so it's pretty brief. But anyway, the lawyer, who I've actually been against this lawyer, Ethan Lowe, he saw emails from Dingfelder. Dingfelder was the commissioner involved, and his wife's private email accounts. Again, they're not private if you're talking about public business. Critically important understanding. You do not have a private email if you're an elected official. It's no such thing if it deals with public business. And if you think it is, and someone else finds out and reports you and you don't produce, now you've committed a crime. Okay. He said Dingfelder never fully complied with the record request. Quote, there were some emails we knew existed from other sources. Remember what I told you about the people who were on the other end of those emails? So they knew that were public records that were no longer retrievable from either the private email accounts, either Mr. or Mrs. Dingfelder's Lowe said. What that tells you is somebody who had written some of these emails back and forth or had these communications was unhappy. And then that commissioner gets the request and thinks that they're going to be smart about it, not remembering there's somebody on the other end of these things. And by not responding, they got, by the time it gets to that point, they got the goods on you. They just want to know if you're going to fall into the trap. Give them up. Okay. So if you go further, in this particular case, Dingfelder resigned from office Monday to settle the lawsuit and an ethics complaint. This is what the people who run the First Amendment Foundation said about it. I think it sends a message that these laws are important and the public's constitutional right to public records and the Sunshine Law can't be ignored, said Virginia Hamrick, an attorney for the First Amendment Foundation. Every person has a right to access to the information, whether it's the most upstanding citizen, the most annoying citizen, or a criminal. They're public's records. Anyone can ask for them, Hamrick said. And that's the point. The last one I have is a report regarding a search of a Destin councilwoman's house. And this was in October of 2021. Again, I try to use recent dates so people think this is an ancient history. This happens right now today, okay? They got a search warrant for this woman's house because of an allegation that she violated the public records law. While they were there, they found evidence of other crimes. The state attorney's office commenced an investigation upon receipt of a complaint from Point Mezzanine LLC, a developer, alleging Destin City Council member Treble Quinn Ramswell had conducted public business on personal electronic devices and concealed the content and nature of communications. Additionally, she failed to disclose those communications as required by the law after the city of Destin received a public records request from Point Mezzanine LLC. Ms. King receives records requests all the time. If she asks you for the records and they're not provided, she's done her job. If you don't produce them and then this happens to you, there's nothing else we can say. That's what it is. An arrest warrant was issued on October 11th for Ms. Ramswell for violation of Chapter 11907 Florida statutes, inspection of records, punishable as a first-degree misdemeanor. This is the state attorney. This is a very common sentiment for state attorneys because they are elected officials who run for office. They want to be popular with the public. One really good way to be popular with the public is to go after what they deem public corruption. So what does she say? This is Ginger Bowden, the state attorney. Ginger Bowden Madden. We take any allegation of misconduct by public servants seriously, and we will enforce the law to ensure the integrity and credibility of our government. Probable cause for the state attorney's office search warrant was based on a first-degree misdemeanor public record violation and a third-degree felony charge of fraud pertaining to public servant concealing, destroying, or altering an official document. It then walks through the affidavit that was provided to give the search warrant. And it said that she did knowingly, willfully, and intentionally conceal numerous public records from the city of Destin on her personal cell phone, et cetera, et cetera, et cetera. The initial records request, which called for documents pertaining to the original condominium project, the recently proposed addition of docking facilities and a right-of-way across the condominium property to Noriega Point, took more than a full month to fulfill. Why did they put that in there? Because it's not supposed to take days or weeks. It's supposed to happen right away. That in itself is a red flag that is going to trigger at some point, if we keep doing it, an investigation, and we do not want to be there. The lawsuit, this lawsuit was fortunately settled early for a cost of $30,000 to the city. So I say this stuff, I'm very animated about it because from my perspective, nobody who does the job that you all do, and I say this for all the counselors, deserves to go through the kind of angst and headache that this kind of thing can bring. And whether you're elected officials or whether you're on a appointed board or whether you're staff, this is not what you signed up for. And it's easy to not get yourselves in trouble if you pay attention to what I've just said. If you have a question, ask it. The wrong approach is, I don't have time for this, or this is not on top of my list to do. If it wasn't before I gave this presentation today, it should be on the top of your list. They are priorities, and they have to be, because at the end of the day, there are a few things that you can do that get you in trouble. This is one, in violation of sunshine is another, violation of ethics is the third. Everything else is noise. You know, there's a lot of times developers putting on pressure. We got to go faster. We got things that are going to fall through. You know, we may bring a lawsuit, but nobody goes to jail for those things. Nobody, but they do for these things. And that's why I'm so emphatic that you understand what we're talking about. With that, if you have any questions, I'm happy to answer. Yes, ma'am.
Okay, on public record requests, if a person requests public record, do a public record request, And if they're asked to be, if they're saying, I want to be anonymous, is that permissible?
They have every right. Now, it's interesting because most folks that want to be anonymous don't know what that actually means. If I go down to the clerk's office and say, I'd like to make a records request, but I want to remain anonymous, the clerk does not have to honor that request. Once she knows who they are, then, and you ask, well, who was it? She can tell you that. But if they don't identify themselves, which they don't have to do, and she doesn't know who they are, then she can't tell you. And nor can she even ask the question, can you fill out this form and tell me your information? No, none of that, none of that. And so someone who legitimately tries to get the records and remain anonymous will use a quickly created email account, with numbers and so forth at Gmail, and they'll send the request in by Gmail, and they'll say, this is what I want. You don't know who they're, magic123@gmail.com or something like that. So I don't know who it is, but it says, I want these records. That is just as if I walked in there and asked someone personally said, this is my name and I'm a lawyer. Doesn't matter. And no, you can't go back and track. Oh, let's look at IT, see if they can track down the IP and the internet addresses. No, you can't do anything. And so there is an ability to not identify yourself and get records. And the people who were really trying to stay anonymous, that's how they do it. But it's a two-part question because just because, like, if I came to the mayor and said, I'd like to make a records request, Mayor, you know who I am, but don't tell anybody else. You have zero obligation to honor that. But if I send you an email where I'm not identified, no, you don't get to find out. And no, you still have to get me the same stuff. You can still ask me for the deposit, and I'll find a way to get it to you. That's on me to figure out how to get it to you without you knowing who I am. But short of that, that's it. So that's how it goes. And no, you don't need to ask why. Why do you need this? Doesn't matter. I don't have to have a reason. There's a particular person who I'm not going to identify, but everybody who does what I do knows. And they make records requests for the sole purpose of hoping you'll screw up so they can sue you. Because under the statute, if you screw up, they get attorney's fees for getting the records. So when I tell you that it's coming to a cottage industry, because they'll request stuff and you go, why does anybody need that? That's the reaction they want you to. Because they want you to not comply. Yes, sir.
Is there a dollar value on the records requests if not fulfilled? Their dollar value. A dollar value
You mean like how much you could be fined
or sue for?
it's based on, well, there's two factors. Number one is, did it cause some damage? So anytime you can prove in any civil case that there's some direct damage related to the failure to comply, like as an example, I don't know if this is what happened in Martin County, but I'm guessing because that's a lot of money. But what I'm guessing happened is you had a developer who was under contract, right? And they were supposed to close by a certain date. The project had a certain value on it. But in order to get further to the next step, they needed records that they couldn't get. And in the meantime, the option expired. They couldn't rescind the contract. Now their deal fell through. So now they're saying, well, we lost X money in profits because y'all didn't timely comply. So you have an approvable damage to the records that you didn't produce.
What about a citizen?
A citizen,
But nothing, just put a public request in, didn't get it in a timely manner.
for the citizen, they can literally, and there are lawyers who will do it because it's lucrative. I'm not a contingency guy, but I could take the case. Let's say the citizen was you. I could take your case as your lawyer on a contingency in a produce records. I'm going to win, and they're going to pay me, and my rate's not cheap, as you know.
Is there a statute of limitations? Like, can you go, let's wait a year, let's keep waiting, and then fees go up and up? Is there statute?
No, there is a statute of limitations for violations of statute, meaning you can't prosecute somebody or can't bring a suit after a certain period of time. Statutory violations, it's either 4 or 5 years, depending on.
I'm talking about the records request that if a person has made. Let's say he keeps waiting, like if I wait longer than a year, then it's my fees.
No. No, the fees accrue once you file a litigation. So in theory, you're in court, and then it's based on how much lawyer work is going on. It's not the lawyer, the clock's not running like a taxi cab sitting in the driveway. The lawyer's got to be doing something.
So it's a lawyer.
But if they're doing something, the answer is yes.
So my question is, public records should be handled in order received, correct?
The requests?
Yes.
No. I get what you're trying to say, but the answer is no. Why? Let's suppose I walk into, I haven't been there, but let's say I walk into wherever the police desk is. This is an actual real life case. I walk in there off the street and I see there's a signage sheet that, you're there to see the chief, or you're there to see detectives or whatever. And it's a signage sheet where and they put down their names. So I walk in off the street. I like a copy of that sheet right there. And you say, well, I need to get with a lawyer on that. I'm not sure I can do this or whatever. Well, let me know if there's no privilege there. They're entitled to it, and they're entitled to it right now. Now, that records request came in at that moment. There might be 3 others that came 2 days ago. But if you have the ability to comply right now with what's in front of you, you comply right now with what you got in front of you. So that's what I mean by it. But if they were all of equal weight, your point would be well taken.
And no approval should have to come from anybody on to these public records, correct?
No approval, but the key and the trick is, and this is where you have so much reliance on, if you don't know how to do it yourself, on having the clerk who then has the good sense to reach out to me when she's got questions, I'm not sure, or maybe somebody in law enforcement. A lot of times, I don't know if the chief has done this, but a lot of times law enforcement is taking special courses on particular things that have to do with criminal investigation and those kinds of records. But either way, in very short order, we determine what's the scope of the request, are there exemptions that need to be asserted, and let's get on it right away. And the more your clerk knows, the less you spend money on me. But I am telling you, if you haven't seen the book, it's a book this thick called Government in the Sunshine. It's the Government in the Sunshine Manual. You can actually download it as a PDF off the Attorney General's website. It's like 250, 300 pages. And about a third or more is the exemptions. But again, most of them don't apply most of the time. But when they do, you have to know to a certain. Anything else? And I got my back turned. Anybody out there have any questions? Okay.
I have a question. It's kind of not about the public records, but it's about the sunshine
Yes.
concerning board members and elected officials going to public meetings, other meetings outside the scope of being here.
Right.
Examples, contractors having meetings and those types of workshops for the public, and then board members and officials shows up at those meetings and speaking. Is that a violation of the sunshine?
No, but there's so many different aspects to it. So at first I thought you were going to talk about, let's say you're a member of this council, but you're also, as I have in several of my cities, at least one or more council people that want to go and watch the planning board work, or the planning and zoning commission, whatever you all call it. And so they're not members of the board, but they are members of the council, and they would like to go see how the development is progressing, what's being talked about. So they're more involved. They're all got good intentions. And then to deal with that issue, where members of this body want to go attend some other committee meetings that they're not a part of, they want to go and observe. We have on the notices of meeting on the agenda, we say, we have a little disclaimer, I'll apply the language to this king. It says, one or more members of other boards and commissions in the council, in the city, may be present at this meeting, which is subject to sunshine. So that they know there's a notice meeting, because sunshine law, we have talked about this, because that's a different lecture. But sunshine clause requires a properly noticed meeting to be held in a public place, and it's required when 2 or more members of the same body are present. And when that happens, you have to have minutes. And so we put on the notice that it's possible, not never guaranteed, that 2 or more members, for example, of the council might be there. Even though they're not participating in the meeting, except to listen. Maybe they'll go to the podium and speak, or maybe they won't. And by making sure that the public knows this possibility, and it will be recorded in the minutes, you've avoided the sunshine law issue. But you asked a little bit different question too, which is, suppose there's a presentation that's going to be made by a contractor developer, and you want to go get more information, and there's going to be another member of the council at the same time. There's a problem with that potentially, depending on how it's handled. If you sit and listen, not a problem, because it's communication between the officials that's the problem. But when does it become a problem? This is a real example I had in Palm Beach County. Sheriff, after 9/11, as many did, Palm Beach has got a significantly large Jewish population. A lot of synagogues, and as a result, they were very concerned about potential terrorist attacks to synagogues. And so the sheriff of Palm Beach County decided it would be a good idea to have a big old breakfast, at, I don't know, some restaurant. And would have, in that meeting, discussion of his plans for the county of how to provide extra security for these facilities. And so all the various other little cities, Palm Beach Gardens and blah, blah, blah. And they came and all of them had breakfast. And then after he got done with his presentation, kind of like me, then he opened up the question. So if I had two members of Palm Beach Gardens sitting there, and the first one asked a question and he answered it, so far we're good. Then the next one, based on the first one's question, asked it, and we're no longer any good. Why? Because it wasn't a public meeting and no minutes were being kept. And it was no success. It was a private, quote unquote, get together, but in a very public place of people to talk about what amounts to city business, right? And so because they were communicating, even though they weren't talking to each other, at least that was what the allegation was, by them asking questions to the sheriff, prompted by the question that the other one asked, that's called the conduit. And you cannot do through a conduit what you can't do one-on-one. So if, for example, you couldn't turn to Mr. Washington right there and ask a question, you couldn't have the same effect by going through me and getting communicated back to Mr. Washington. That's called the conduit. Yes, he doesn't get in trouble in that case. Conduit, it's fine. But you guys have a problem. And so if you've seen the film, I make this reference to something that I think most of you are old enough to remember when they had the commercial for light beer from Miller. It was less taste great, less filling. And there was always the instigator in the middle. And he'd be cooking, hey, that guy says it tastes great. He goes, oh, it's less filling. And then next thing you know, these two guys fighting, and the conduit of the whole problem is just stepping back and laughing at the whole deal. And that's kind of like it happens. Because let's suppose you're at a social event and a citizen comes up to you. Citizen's not going to get in trouble. There's nothing private citizens. There's like you. So I go to you at a party in Toronto and say, hey, what do you think about that development, you know? And then you tell them, well, you know, I think it's a good idea, I think it's a bad idea, whatever you say. And they say, well, you know, I agree with you, but I just talked to Councilman Daniels, and they told me this. What do you think about that? Now, as soon as you give them that information, they run the, hey, I just talked to Councilwoman Randolph, and she said, blah, blah, blah. Now, they're the conduit, but y'all are having a problem. So you have to be alert for that. That's a whole other section of lecture. I'm happy to go into much more detail about that, but for now, I was here for public records. And these things can be so tied together. Why? If I can make a request for all the emails, and you can bet what I'm looking for if I make this request. If I say to you, Mr. Washington, I want all your emails regarding city business for the last year. Now, when all means all, that means whether you're doing it with another council member or a member of the public, all means all. If I have to show up and if you provide the records, and I see that you've been communicating with another council member, you now have erased the public record problem because you provided it to me, but you created the sunshine problem. So now you're going to have a different issue. Which is why you have to always be careful what you're writing, who you're writing to. And as you would hear me say in the sunshine, and I'll give you a preview of that. A lot of times you get these blind email lists, right? Where maybe 300 or 400 email addresses. And I don't know who these people are because they got email addresses like, you know, hip hop 103 or picture car 124 or whatever. You don't know who it is. You don't have a clue who it's just an email address. And like mine's Worlds Matter or double guns at Gmail. Okay, but you wouldn't know that to me unless you just happen to know that to me. So you think you're communicating with citizens, but you may be communicating with each other. You don't even know. So you don't want to respond to these emails that are like that on a reply all. You know, there's a lot of other cautions you take. But again, those are public records. So if you happen to create a violation in that way, you have a problem.
You find out how the records request and you haven't got any traction. What's the next step?
Well, for the benefit of the town, I'm going to tell you the next step is keep trying. But if you're asking me as a citizen, what the next step you can take is you can make a complaint down to the state attorney's office. And that's why this lecture or this presentation is so important, because that's not where I want anybody to.
So I have to kind of shift a little bit. We're at 7:45.
I talk
And you
about,
have the capacity ordinance in here as well.
yeah, I can talk about it quickly.
Okay.
It's very, the pass-through ordinance, I hope will be brought up for the next meeting as a first reading. what it does is it allows the town to pass along a lot of the costs spent in legal review and consulting review, for example, Ms. Almieri, or the engineering firms, whoever it is, to developments that are going to cost us a lot of money and a lot of review time and so forth. If I use the bill that I just got through looking at today, I didn't tally up, but I promise you, at least half, maybe 3/4 of it, if we had the pass-through ordinance, would have been paid for by somebody else. Because what the pass-through ordinance does is when the developer comes in or the landowner comes in, they pay a deposit, and then, and they're, it's not for everything. It's not for, when you come renovate your house. It's for, you're gonna plat a piece of land and build condos or apartments, or you're gonna build a commercial project, and it's gonna have to be reviewed. You look at all these other things that you've seen now cost a lot of money to get through and to do it right. And so the idea is that the developer pays the cost of those things that you otherwise shouldn't have to be carrying that burden. And there's logic to it too. The logic is the developer can always pull the plug. You've already spent the money, you get nothing. It's not like your taxes are going to go up, because if they quit, then you don't have anything, but you spent the money anyway, on me, on Carol, on whoever else. The idea is, if you're going to put us through that work, which we will do, you're going to pay that freight. And so in a very short order, you get a deposit. I think you call for 5,000, you can go up if you want. Make them put up that deposit, and then when you use that to pay the officials that you have to use, the consultants, and when that money runs out, so does the processing until they put up more money. And that's how it goes. And so you'll see an immediate drop in any work related to development in your costs, because those costs will get passed on to the people who should be paying and not you.
I do have a question. So any agreements that we already have with this effect?
It will affect them to the extent they have to come in for anything that's called out in the ordinance going forward. So if they need an amendment, if they need a new permit of some sort, if they want to change the development agreement, if they want to rezone because they decided at this point this use was good, but now they want a different use. Like they said, apartments were good, but now condos have come back and want to change the condos. So on a go forward basis, any of those things where they're going to have to, which will trigger, which is spelled out there, but it is rezoning, all that are spelled out in the ordinance. Yeah, they would be liable for it on a go forward basis. Yes. More questions on that? So I hope that'll be on first
I
reading.
have a question. I'm not a board member, but I have a question with regard to the pass-through. If it is a citizen who wants to build in the town of Eatonville, how would this ordinance affect?
Depends on what they want to do. If you see the ordinance, it tells you what the categories are that trigger the ordinance. And it gives the city through, right now we don't have a full-time CAO, but it gives the city or through the executive the ability in certain circumstances to say, we're going to wait for its individual. But an individual can come in here and want to do a really large development. We got people like that in Maitland who are individuals, but they're also multimillionaires who want to come and develop. I don't care whether it's because I want them to pay the freight. And so that's a possibility. And so it's not that they're an individual. It's A, is it triggered by what are they asking for? And B, how much work is going to be involved? It's one thing to say, as I said, I want to remodel my house. It's another thing to say, I want to take this block and rebuild everything on the block.
Thank you.
Thank you guys for being power.
The time is 7:42. Here, another break before we go into our 7 hours town council meeting, or you want to go right into it? Okay, so 5 minutes. So we'll go ahead and adjourn. So I move that we adjourn from the town council workshop meeting. It's been moved, seconded, all in favor, say aye. Aye, all opposed. Now, adjourn from our workshop, we'll start our council meeting in about 5 minutes. So 7:45.
I'll be This is the handout. How are you?
All right, we have a couple of minutes for those of you that weren't here earlier, we go ahead and silence your phones or place them on vibrate in anticipation for tonight's If we go ahead and get to our seats. It is 7:45, October 4th, 2022. We are opening up for the Eatonville regular council meeting. Ms. Quinn, do we have a quorum?
Yes, yeah.
Will you please stand for invocation and pledge of allegiance?
Amen.
I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
First item on the agenda is the approval of the agenda, and I do need to right away make a change. You should have an amended agenda, number one. Item number 8. Mr. Lover is stuck in South Florida, so he will not be in here for this, for that council decision, and I kind of wanted him here. So number 8, we're going to take that, if that's okay with you. Besides that, does anyone have any other amendments to the agenda? All right, so
Man, it appears that we have a lot prepared, so I'm just saying, in essence of time, can we look at some of these items? Because a lot of it is repeat stuff, and I'm pretty sure a lot of people want to talk about the storm and different things like that. It's possibly take some of this stuff, so we can give adequate time to citizens to be able to talk and talk to some other matters that may be coming up.
well, the consent agenda is one big vote. You don't pull those out individually.
But, so this approval to upgrade, and how we want to talk about that, because was that in the budget,
That
the
was
upgrade?
this king is second. Yes,
What are you asking?
the approval to upgrade,
That's fine.
that's fine, sorry.
Yes.
Yes, yes. All right, so the motion is on the floor to approve the agenda with the amendment of number 8 being tabled. It's been moved, is there a second? It's been moved, the second, all in favor, say aye. Aye, all opposed. The next item, citizen participation, 3 minutes, please. Ms. King.
Yes. We have Eddie Cole.
Good evening, everyone. Mayor and Council. A couple things. On August 12th, in August of 2020, I signed a agreement with Coronavirus Fiscal Recovery Fund. In that fund, we had $550,000 given to the town. Matter of fact, it was about $1 million given to the town. On that, in our 2021 budget, we put as priorities $300,000 for wastewater tower repair and renovation, $200,000 for meter replacement program, and $50,000 for valve repair replacement program. That was on September 24th, 2021. We had a water break the other day, and we've been talking about this for the longest. We can build all the buildings we want, have the bottom right, the top means nothing. So in my house, if my toilet goes out, I can close that valve and use the rest of my home. Our city is set now, if my toilet goes out, I have to go outside and shut the whole house down to fix the toilet. That is devastating to all of us, to the whole community. And we had a pipe break on one side of the city, and the whole city had to shut down. Communication is not great. Restaurants have to be told first. Daycares have to be told first. Schools got to be told. So the communication can do better. My concern is this. We put this money away. We have this money. So this is not money that has to be found. We have $550,000 somewhere. I'm glad we started with the meters, but when we see what our situation is, we got to reprioritize. And I think what needs to be first is all valves in the city. Find out where the valve is and where we can shut off, even if it's unfortunate, we have to shut off the west side, but the whole entire city or the east side and not the west side because we get that one. That is a priority. So I would like to know, where's that 550,000? Where are we at on those? The other part is we got another 550,000. So it's a total of $1 million. Where's that at? Because it's a certain time before we can lose it. And anybody who wants to ask, American Rescue Plan Act Coronavirus Recovery Fund Agreement. Get an opportunity to read that and you can see what we need to do. I also think we need to get the report on the $685,000 from Congresswoman Val Deming's office and see what the timeline is on that so we don't end up losing it. Because we'll lose it. There's certain things you have to do. I need to know the report on the money from Governor DeSantis. What's the timelines on that? Because if we don't, before you know it, we'll be making some excuses. So I hope we can get that, get those things in order. But one of the major things is communication. We have to do better communication. But I would like to know tonight about that 550,000, and I would like to know about the other one and when can we know?
Thank you. Ms. Hood, next.
Yes, we have Ryan Nolan.
Everyone, council, mayor, citizens, Ryan Novak, residents, Eatonville Lab, everyone weathered the storm with minimal damages. Couple of things, I guess, let me start off first with a couple of comments from the CRA earlier. I just want to thank everybody that was there for adjusting what I thought were exorbitant line items. So, thank you. Regarding part-time employment, generally, they don't get benefits, so that's probably not something to worry about. Mr. Shepherd, thank you for addressing Florida Statute 119. I've discussed it a number of times in the past, and you guys may have heard of Florida Man, and it's a thing because of exactly that. Our laws for transparency when it comes to just general things is so good that anyone can get these things, and that's why Florida Man is everywhere, because they can get our records easily. The same with our amazing law enforcement. Keep in mind that they have body cameras, which are also available to do records requests. So, pickleball. So that was my last item. So I am planning on playing pickleball tomorrow evening at 5:30 over at Katie Way Park. If anyone is interested and would like to join and enjoy this game that I would really like to bring to the town of Eatonville, the people of Winter Park that I've spoken to while I was there at these courts, they say that this location, Katie Way Park, is very inconvenient for them. And so Eatonville, again, prime location, has also a prime opportunity to court a lot of just people who want to come in and enjoy the sport in our community. And so not only would that bring bodies here, but additional people who go to also spend their money in our restaurants and things like that. Thank you very much.
Thank you.
5:30, Katie.
Thank you, Ms. Katie.
We have Crystal Wood.
Park subdivision. And I believe the next council meeting, they're going to rezoning the old hospital building. And most of the residents are against it, that I think spoken with, are against it. For several reasons. The property that's at our playground, they have a entrance way in our subdivision where they come and go speeding down the road to get into that side gate that's supposed to be for emergency vehicles. proposing to rezone it so they can do some other things, and so Tesla can do some other things in the building. And, it's already causing congestion going in and out of our subdivision. Also on Lake Lovely side, those transportation trucks are backing up. And, you can't get in and out of their property. You can't get on to Kennedy. And I think that when they rezone it, once we open that can of worms, we're not gonna be able to close it back up. Traffic is already bad down, especially for us down there at that end. So I think that, we want it opposed, not to be approved. Because it's not conducive to our neighborhood. It's not to live in our neighborhood.
Thank you.
We have Angela Thomas.
Angela Thomas, 427 Park Street. Mine was in regards to public record, and I'm not sure if you have, Mr. Pope, I'm not sure what you had was a copy of those papers. So since you said it's public record, can I get a copy of the papers you got as well, as I want the same thing that you get already requested from me?
That's it. So what's it?
All right, next item. Approval of the first reading ordinance 2022-3 businesses in the town of Eatonville code ordinances. Ms. King.
Ordinance 2022-3, ordinance of the town of Eatonville, Florida. Businesses in the town of Eatonville, code of ordinances concerning the registration and operation of rental homes, providing applicability, providing for registration, inspections, and fees, providing for requirements and notice, providing for interpretation and enforcement, providing for conflicts, providing for severability, providing for inclusion in the code, and providing for an effective date.
The motion is on the floor to approve. Oh, this is public hearing. If there is an audience that would like to speak to this particular item, now would be that time.
Thomas, 427 Park Street. I think the last time you guys brought this to us, it did include the motel, hotel suite. I see that y'all have taken that out and why. Because that is not being rented as though it is a motel. I know it's on here. But anyway, it's not being rented as a day-to-day operation of a motel, hotel suite. It's being rented as a residence for these people. So what would constitute the motel, hotel suite, or whatever it's called, in-town suite? If they stay over 30 days, does that mean that it is a resident? Or if they stay 30 days and I move them to another room, I'm still at the same address? So why did y'all take that out of this ordinance? It's in there.
Does anyone else want to speak to this? All right, the public part of this hearing is now closed. Are there any questions from the council?
Number 13, question. Tenant screening. Landlord shall perform all the following screenings required for all tenants prior to move in. Is that staying in or that's coming out? That's 13. F, G, and H. It's red.
Since they're coming out, are striked out, right?
The underlined is additions,
Right.
and the strikeout is the one being removed.
So we're telling tenants, or we're telling landlords that they have to background check people.
So I guess my question is, who else went to it?
My question still stands. Are we telling landlords that they have to background check, criminal background check, the people that's moving to their areas?
Would you prefer, I mean, is it, would you prefer that the town doesn't?
I'll regress. Attorney Shepard,
Yeah, okay, now I know I'm being talked to, I wasn't sure.
I was asking a question for staff since it was put in. Have you seen this document?
I think we helped prepare it. I don't know if we prepared it, but we definitely reviewed it.
I think, Attorney Brackett is supposed to work.
Who?
Attorney Brackett.
And it wouldn't be the first, one. There are a number of communities that have something similar. And your question is, does it require the landlord get a background check for the tenant? Is that what you're asking?
Yes.
Let me look at it real quickly. They typically do, and I would be surprised if this one doesn't.
It's not, it's the pages are, it's page 8 of 12. Income and employment verification. Landlord shall obtain income and employment verification from every prospective tenant.
And yes, so the answer is yes, it's there.
So it's there. Is that feasible? I'm asking staff, not you, Attorney Shepard.
I didn't even hear the question.
I'm asking staff, why is this feasible?
And again, I'm asking you, who else would you prefer that we collect the fee and then the town doesn't?
So, Mayor, I'm saying, are you gonna tell a landlord that they have to, if they're gonna rent their property, they're gonna have to background check somebody? You're gonna tell them that they have to do an income verification? Prime example, we just came out of a major storm. You're gonna tell somebody that you're gonna have to provide income in order for you to move into my property? Because it says shall. Relative reference, landlord shall obtain and verify contact information for all previous landlords within the last 3 years. So are we not about second chances and all those different things, or are we just here to crucify people?
I mean, currently right now, apartment landlords usually do some sort of background check now. Whether it's a storm or not, even if it's a storm, you don't throw away all of your processes because of a storm, number one. Number two, we've said that in order to be on a planning and zoning or any board, that you didn't want them to have, you wanted them to have background checks. So I'm not, so I think that a landlord should have some sort of responsibility to do some sort of background check. Now, what is acceptable in that background check, I think that would be different. You know, if in my background, I was caught, with a small amount of illicit drugs, I think that's so different than if I have a background with more serious criminal activities. So I think we can look at what's acceptable, what's not acceptable. But something should be done.
In reference to Ms. Thomas' question, why was the hotel taken out of?
Wait a minute, hold on, Councilman Washington, you have a question about that statement?
No.
Another question, okay. So are hotels and motels and rooming houses, are they not?
They're different. That's a different thing altogether.
So it has hotel in here, it has boarding house, rooming house, lodging house. So with the motel needs to be in here in addition to all of that for the definition.
Go back to the section.
On page 3 of 12 is.
Yeah, these are definitions, but I'm not sure where they come into. So those are defined terms, but what is the question regarding?
Well, earlier it was stated that it was taken out. But if you go to 5 of 12, it says rooming unit includes each and every bedroom within a structure such as a boarding house, a fraternity, a sorority, a motel, a hotel, a hospital, nursing home, that better than saying?
Well, first of all, let me make sure. you
So the question was, why was the motel taken out?
I don't know because I wasn't part of that drafting, but I will tell you this. One of the things that I think might be being confused, you have to look at what portion of the ordinance you're concerned with. Because frequently we define terms of things that need to be defined so that when we say these things are excluded from the application of this ordinance, you know what we're talking about. So for example, where it says, an owner occupied rental unit. I do not know, I'll have to look at the portion, but that may be an exclusion or an inclusion. If you look at the other things, everything you said, well, that's in here as a definition in the section we're talking about. But when it says, for example, a hotel, I don't know that a hotel is being regulated by this ordinance, but it's defined so that you know what it is or isn't. So when you look at this ordinance, so if you had said a specific provision, what is it that it applies to? And it is or isn't hotels. That's the idea. So if you look through the section, you have to say, okay, well, does this section apply to hotels? Okay, then I'll tell you. Or does it apply to motels? Or does it apply to one of the other words in here that was room and board or whatever it was, but owner occupied rental unit. And so just because a term is defined, it's defined for two reasons: because the ordinance applies, or because the ordinance doesn't apply, but you're saying what it doesn't apply to. So you'd have to be more specific to the question for me to tell you which one is which.
And also, I think because hotels and motor houses, they be under regulation.
Yeah, they're
of the
state of Florida.
Hotel restaurant division.
So is this part still open?
Page 11, 12. So renting without a license after 30 days notice shall be subject to no fine per unit, and also be a misdemeanor offense. That's his question. Honestly, as I stated earlier, and last time we went through this, I think this needs to be a meeting all by itself, that we just address this and really work on this document and give Attorney Shepherd and staff and all that a good time to work through this. And keep bringing stuff back that I don't think has been truly vetted.
If I could just comment, that this is what I was looking for. This is a good example of what I'm trying to explain by the definitions are there to include and to exclude. Under section 1270A, the provisions of this article shall apply to rental homes, which include any dwelling or group of dwelling units as defined below, including those units in a single family unit, condominium, cooperative, or mobile home dwelling located in the town that is at any time available for rent or lease for a period of not less than 180 days. This article does not apply to hotels, motels as defined in below, as used in this section, the term available for rent and so forth. So even though there's a definition for hotels, motels, it's so that you know this doesn't apply to them.
So then I guess the question is, if the concern is the motel, is it covered under this ordinance?
No, it would be covered by state law.
I say not correct.
There's taxes that apply to hotels, bed tax, all kinds of stuff.
Already.
You ever been in a hotel, you see the little sticker on the back of the door? It takes 3 lawyers to read it, but it's got all that.
So are we collecting? Okay, this will be a final question. Are we collecting city tax or rooming tax for the hotel?
Not in this ordinance, I don't think so.
No, I'm saying right now for the
That
hotel.
I think it's a state tax, but I'm not sure who collects it. Pretty sure it's a state tax.
Because normally you get like
Or a county.
normally you get a county or
Yeah,
city
right.
hotel room tax.
Right,
That's
that's-
yeah. So are we collecting the bed tax on that part?
Not for this thing. It's interesting because what the state has done, and this goes back now, maybe a half dozen years, maybe longer. That is, the older I get, the shorter things seem that are actually longer. There was no regulation of short-term rentals, which is what this is really trying to control. Right, what you're trying to avoid is you're in a residential neighborhood and somebody buys a house next to you And every week in and week out, there's somebody new that's coming in over there. They're renting it to kids for spring break. They're doing whatever. This is what is the kind of thing. They're using it as an Airbnb, all of that.
So basically, when we're trying to stop Airbnb from coming in, we just need to say we're trying to stop Airbnb and be straightforward to it.
Except that you can't pick on them in that regard. That's why you use a short-term rental. And here's the other thing. What's critically important is the state legislature took away the right to regulate not allowing them. They didn't take away the right to make them register. And that's what this is about. And so if you had an ordinance on the book, which a lot of places did, a lot of places didn't, when the legislature came in and preempted the field, which means they took it away from our ability to do anything else. They said, you can keep what you have. If you don't currently allow it in certain zoning districts, then you can keep that. But you can't further restrict it. And if you try to change the ordinance that you already have on the books, you will lose all of its protection. And so what that creates is a situation, for example, in Ponce Inlet, where they have certain places where condos cannot be rented on a short-term basis because that ordinance existed prior to the state law. But once it came on after, we can't do anything about it. And we get a lot of complaints, but our hands are tied. What you can do with all of them, though, is require that the landlords register so you know who's coming in and out, and you try to make them act in a responsible way. So that's why some of the background stuff is here. Because if you have somebody who's an investor who's just trying to maximize as fast as they can return on money, and you don't make them jump through any hoops, then you can end up in really unfortunate situations of who's coming in and who's going and who's taking care, and it can go badly quickly. So by registering, you can't tell them to stop, but you can make them come into compliance in a way that you can know who's there, you can know that they've been background checked, if that's what you want. You don't have to. You can have some ability to at least have your eyes wide open as to what's going on in your community, how many people are doing it, for example. That's the purpose of it.
Are there any other questions? No other questions? So the motion is on the floor to approve the first reading of ordinance 2022-3, businesses in the town of Eatonville for ordinances. It's been moved. Is there a second? I mean, it's obviously not a second. What is it that you want added to? What is missing from the ordinance that you chose? Because something has to be done. Councilwoman Randolph, is there anything missing from this ordinance that you think should be here?
I just think that you just need a little bit more time to study. And, I think we've already addressed this one time before. See, there's a lot of things that's being deleted, and so I just think it's just not enough time. Let's go back and we have a special meeting for this, so we have a little bit more time to analyze it a little more. I really believe that something does need to be done. I just want to give myself time. I'm not sure.
Okay, Councilman Marlon, is there anything specific that is not here that you think should be here to make it stronger?
I'm gonna agree with Councilwoman Randolph. Like I said, in the packet on Friday, and then you will be trying to analyze it. It's not enough time. And then my next question would be, is how we complete the study for the town. So how many rental properties do we have in the town right now?
Any other questions that you'd like to answer?
I mean, that's a valid question, man. I'm saying.
I didn't say a process, but if I don't have the information, if you give me
So,
all of the questions, we'll have those, because this is
so
not the first time we've seen
Okay.
this.
right, and I've asked this question before. So to piggyback, if you bring something to me with enough information, I can make an educated decision. But if I don't have all the adequate data, I can't make a decision on it. So how we did a study on the impact of rentals in the historic town of Eatonville.
So now you want an impact study on you want to study the impact of rental housing
Okay,
in historic town. I'm asking the
No.
question, is that what you want?
no, I'll rephrase it. How do we come up with that this was needed for the historic town of Eatonville?
If you just think about all the discussions we've had, rooming houses has been a discussion. And if I'm not mistaken, it was, if I remember, before I was on council, someone came up and made a statement that if you're going to have rooming houses in the town, then we should have some sort of way to track them through some sort of business
Okay, I agree with that.
licensing and everything like that. So
So
I mean, something has to be done. What I'm asking is, it's gonna be brought before the council again. If there are elements in this ordinance that you think should be added, then that's what I'm asking now. If you're gonna say no, then have a strong reason. It can't keep being, I don't have enough information, because we have to start somewhere. And if we feel that, if we start here, and we feel that it's not strong enough in certain areas, then we can amend those. But if we have nothing, then, and we keep coming back to this point.
I'll first, Deputy Chief. Yes, sir. In your expertise over the last year, do you know, or maybe you have any knowledge of how many incidents maybe have happened at a rooming house or a rental property in the historic town of Eatonville?
Deputy Chief, before you finish, this happens quite often every meeting. You know what I'm saying? If there are questions that you would like for the staff to answer, it's about time to start it coming through. I am more than willing to get you the information. If you would like to send the questions, we'll bring it back, but
Okay,
people start.
I'll send it to
doing this
Ms.
properly.
I'll send it to Ms. King, but when you're asking me this and every answer is, I don't have an answer, I have to get back to you.
Like I said, you haven't asked questions.
Okay.
So if you send the questions, we'll get the answers. So guys, for like a second. Oh, I'm sorry. If they have, but we have no interaction.
I mean, the problem is, I mean, especially wholesale or maybe like a business like that, you have a big one. That's something we know.
And I think earlier it stated that they're under the state licensing, but one of the questions would be if it's supposed to be a short-term rental, but you know that people have lived there
Right.
a long time, how do we regulate that?
Well, that's fine. It is okay. Yeah, I don't, that part of the registration, you know, Councilman Marlon Daniels asked a question, how many rentals are there? You find out by having a registration requirement. That's how you get your list. And so that's part of it. But I was going to suggest that if, and I'm not sure that I'm hearing this right, but if I'm hearing it that that the issue is we want more time to study and consider, then probably the thing to do from this point forward. Without this, it's not going to come back again. Is to table it for either a workshop or a future meeting, bring it back. And then at that time, if you had enough time to study, again, the first reading is exactly that. It's where you get the opportunity to change things to your liking. So let's say in a couple of weeks, now you have a chance to study and you've asked questions, you know, whatever, then you come back and say, okay, like this, don't like that, here's what I think. I would move approval on first reading with the following changes, sort of like you went through the budget, you know, kind of a line item situation. And then we change it and bring it back to you. So if you don't like background checks, they come out. If you want different things in that are legal to do, because again, we're under the overarching regulatory structure of the state legislature who said there's only certain things we're allowed to do when it comes to short-term rentals. And one of them is not restricting them. If we didn't already have an ordinance. But so we can't make Airbnbs go away, as an example. But what we can do is require things like registrations, background checks, you know, make them keep property clean and safe, fire inspection, that sort of stuff. So that's what we're trying to accomplish here. And so the appropriate motion, I believe, if I understood correctly, unless you really want it to die, would be to table it to a future date and then bring it back. And then hopefully you'll have your questions and or your concerns. And we can work through it, like y'all did the budget.
How much percentage did you have input on this? Like, how much did you?
Me personally, I didn't. It was my associate, Pat Brackens, I think, who did it according to what I was hearing. But we've done these in, I think, I don't know if there's a city we have that doesn't have something like this.
Because the board of the citizens were considered, the hotel is a definite hotspot that we would like to have addressed, that citizens and as board members, and for it to be taken out, that it's our,
That's a state legislation thing, I'm pretty sure.
so we can add teeth to the state legislative part.
When the term is called preemption, when the state preempts an area to itself, then other than perhaps imposing tax, like we talked about, a bed tax, then we can't do it. So for example, here's some things that we can't do, even if we want to. They preempted us in the area of firearms regulation. So whether you can or can't have a gun on or around public property, whether we like it or don't like it, doesn't matter. The state has said, you can't legislate this. Smoking, maybe you like smoking, maybe you hate smoking. Doesn't matter whether it's restaurants, bars, parks, whatever. We don't have any say. It's called the Florida Clean Indoor Air Act. It's preemptive. And there's a number of other laws that are preemptive as to what we can do. And so when you hear state legislators running and say, we believe in home rule and local control, that's what they say when they're running, but not when they get elected. They take as much away from you as quickly as they can. And one of the things they took away from us is the ability to say, for example, we don't want Airbnbs here, if that's what we want, or whatever. And so it's preemptive. And so that's why even within the space of short-term rental regulation, we're not saying you can't do it because we can't say that. What we are saying is you need to register with us and then various other things. And so to your point, I understand why you want to be dealing with a hotel, but other than from a standpoint of code enforcement, things of that nature, there's nothing we can really do there.
Okay, next item on the agenda is the consent agenda.
So they would come back to it.
It already talked about.
That motion you approved it, but you can still table the whole idea and bring it back later. If you don't, it's never done.
That's what he said. That's what he said.
It died for lack of second on the first reading too, right?
Yes.
The first time we brought it up here. I mean, I'll do it, but
Well, I'm assuming, again, I'm not trying to count votes, but I thought what I'm hearing is we need more time to think about it and figure out what our questions are. So that would mean, let's bring it back for a future first reading, whether that's the next meeting or 2 meetings from now, or whatever. And by then, you'll have your questions and I'll be ready to answer whatever it is, make whatever changes. But the beauty of the first reading is you can say, now I know, I like this, I don't like that, I want to change this, and that's what we do. We didn't change it, however you want.
so are you wanting a workshop?
No, just someone make a motion if it's,
Built in as well?
because one motion dies doesn't mean the whole thing dies unless there are no other motions. So I've suggested that the next motion should be on this item, a motion table. If there's not, then it's over.
All right, so the motion is on the floor to table the approval of the first reading of ordinance 2022-3 and bring it back for the October 18th agenda.
If that's the one you want, that's fine.
Second discussion. Is that enough time for us to give our input on the board? Rather go to November. So we definitely gotta address the issues that we have. I have a couple of issues too.
So,
I would need November.
so would you like for October 18th to be a workshop on it? So to be tabled until the first Tuesday in November, I'm not sure what date that would be.
First Tuesday in November will be the 7th.
So we tabled until November 7th, however, bring it back October 18th to be a workshop item.
And we can make changes there too, if that's what you decide to do. Just say, hey, we'd like to see this rewritten, so the new first reading, we have it in there, or have some options or alternatives. You know, different language, you can do all.
So that is Motion's on the floor.
And moved in second.
It's been moved in second to be tabled on the 7th. Workshop on the 18th. All in favor, say aye. Aye. All opposed. All right, the next item is the consent agenda. I move that we approve the consent agenda.
Second.
It's been moved in second. All in favor, say aye. Aye. All opposed. For council decisions, item number 6 has been. Item number 8 has been tabled earlier for the adjustment of the agenda. So we're down to the approval of memorandum of understanding between the town of Eatonville and the Chamber of Commerce. The motion is on the floor to approve the memorandum of understanding between the town of Eatonville and the Chamber of Commerce. It's been moved. Is there a second?
Second.
Discussion.
It's seconded with discussion. Vice Mayor.
Yes. Under the second whereas, for the Chamber of Commerce, I have a plan of action for that to advance businesses. Also, the third, whereas we'll promote, I would like that, it's like a business plan or a plan on how you plan on doing that. The fourth whereas, I would like it to be the council or whom we have a designee to be the initial department, you know, I see that it's the mayor's office. I'd like for us as a board to make that decision. And if we can strike out the, however, the mayor has the sole discretion to designate a different department. I was wondering, could we strike that out because we as a board will make that decision. Also, the participating events, I guess we're saying Founders Day and MLK. For the participation, that's under the promotion service, town of Eatonville. Also, the council, the mayor and council and his designee will have the connection with written markings and communication. So basically bringing it before us to make the necessary adjustments if there are any to that. I didn't mind using the town seal as long as we all are okay with that. And those were just the changes that I had.
The other thing I would say that the mayor, I mean, it is not about the mayor, how the mayor does have the sole discretion, it's a department of staff.
That's why I'm asking you and saying that we as a board, mind is that we all be in a decision making. Like I said, to strike out and have the sole discretion. I think that that's all. That should be us, and not just the mayor. Position. So that was just my recommendations. Vote them up and down.
Any other statements?
The administration. I mean, let them do it. I don't be a part of that. Dictate whatever. It's the mayor, Anthony, she told me, she told me, it's not with, I mean, that's fine.
We don't want this to be perceived in any way that the town is in control of the chamber. The chamber can stand on their own. They are a legitimate business entity in the community. They are 501c3. And by no means should we be, we should be active. They have a responsibility that they have to do and that they will do here in the town. So far, they have been doing just that. I just don't think that we should be playing a role in any way of dictating to them as to that they have to comply with anything that we want here in the town. They do very good right now, communicating and doing all the things that they want to do, but I just don't think we should be in the business of trying to indirectly or directly running a chamber. They do have a president, they do have board members, they have everything in place that regular chambers do. They're very functional, they're very active, being a welcome center in Eatonville. We don't want this to be going over the limit as far as the town's responsibility. We're here to support the chamber, and the chamber is here to support and promote the town of Eatonville.
Councilwoman, is there something in the document that is spurring that statement?
Okay, as far as displaying the town literature and all of that, that's fine, that's great. There's some other language in here. But it says the town of Eatonville through the mayor or designee, or the Chamber of Commerce through its authorized representative for its convenience without pause. Telling me to understand, I understand that, the memo, I understand that. When it says, whereas on first sheet, the mayor's office is designated for the Eatonville Town Department. What do you mean by that?
I mean, if anything comes up regarding this memorandum of understanding, they're gonna contact the town. I mean, that's all this is saying to me. This is the administration part of this memorandum of understanding, which is under the auspices of the mayor. I mean, it's nothing, this office is not gonna run. It's just simply going to administer this document like in another administration. Division of the town. That's
Hey, Councilwoman Randolph, everything you're saying is true. Only thing I'm saying is that the council will pick that designee on first. The mayor doesn't have the sole discretion to designate anybody because we would do it. That's all I'm basing on. We as a board will designate who is in co-partnering with the chamber of commerce. Everything you're saying, I agree with. So all I'm saying is that the board will designate someone to be. However we choose to put somebody, whether we created a person to be, we developed a new position. We wanted a recreation department to be open. We as a board would designate that. Not the mayor, they don't have the mayor department will have the sole discretion on designating that. That's all I'm saying. That's it. We won't be a part, we'll be helping them out, and I just need a plan of action in advance of the business and how you promote this. So that's all I'm asking for. Just their plan of action in that, and have us to designate whatever we want, whatever person we want to put over partnering with the chamber, not over them, but partnering with them as far as the designee from the team. That's all.
Can we talk?
I was hearing a couple.
Because it just seems that every time there's something to
But this
deal
louder.
and I try not to have a lot to say in here, I will listen. But it seems like under Vonda Wilder, Eatonville Chamber of Commerce, Johnson. It appears to me, and I could be wrong, but every time there's something to do with the Eatonville Chamber of Commerce, there's always something wrong. It always has to go into so many details, and I'm feeling very passionate right now. I spent my money on this chamber. You can't believe that I already did like to talk loud. I have spent my money. I have not asked this town for anything. The one time the town gave me money, guess what happened? The town CRA took that money and did whatever they wanted to do with it. And nobody answered me yet. What happened to my money? They destroyed my building. It cost me $30,000 out of my pocket to get my building back up and running. I've been in this community since 2014. I've done nothing but good stuff in this community. I don't ask for anything. I come in, I sit in these meetings. Anybody that calls LaVonda, I take care of it. You needed information on COVID, I had COVID stuff. I do everything in this community. You can fire an individual and he can come in this building and run this town. You can give money to somebody that clearly is misappropriating funds, and you guys don't have a problem with it. I asked about my money so many times. What happened to my money for the building? I'm sitting in here today. I'm not asking you guys to give me anything. When I asked to become a welcome center for the town of Eatonville, I didn't ask for one penny. I didn't ask for one penny because one thing that I can tell you is that my credit score is 825. I make good money. I made good money. I have a master's in psychology. I chose Eatonville. Everybody in this place has been in my building except for 2 people. I sat here tonight to look at how many people have not been in the Eatonville Chamber of Commerce or C2M Nutrition, which is where the chamber came from. I take care of the town of Eatonville. Anybody that has ever spoken to LaVonda Wilder will hear her say, I'm an honorary member of the town of Eatonville. Francis Jerry, the Francis Jerry Park that you guys named, that's my grandmother. I belong here just like everybody else. I spend my money, I paid my time to be in the town of Eatonville. Why do I have to go through all this?
Ms. Wilder, I think part of that is not here. Part of it is directed here, but
Yes.
why not?
I just don't understand.
I don't think it's here.
No,
wait,
y'all
ain't right.
Wait, I have a question.
Y'all ain't right.
Ms. Wilder, could you be specific? Was it the last part of the conversation?
Well, I'm really
Or
trying to
the
figure
plan
out,
of action.
first off, why I have to have this memo.
Yeah.
The first thing happened to me when you gave me a grant that I never saw in my hands. Then they put what is that thing called? A lien on my property. They weren't putting liens on any property until I asked for money. So I'm starting to feel like I'm being singled out. If you don't want the services, just say you don't want the services.
So if you don't, when it first came up, one of the things I said at the beginning of the memorandum of understanding, if the town is going to give you funds, that's number one. Number two, the only other reason I'd say that you need a memorandum of understanding who officially are going to represent the town. The conversations that I've had is in regards to if you are going to be the welcome center, I felt that money should be somewhere involved, because even if we ask you to support events or do anything, if there's going to be a cost, then we should at least set some sort of a budget up to what amount that would be. And that was my thing. In regards to a plan of action,
But guess what, Ms. Scott? You had a person, I was in here one day, that you guys gave money to, and I know they didn't do this. And I'm trying to just be fair, because one thing I hate doing is airing dirty laundry about this town. You know how many people call me, news stations and ask stuff, but I always support this town because I love this community. I love watching kids walk down the street. I have community garden groundbreaking Saturday. I love this community, but I'm starting to feel like the community is not being open and welcome to me and the services that I can provide. I sit on a lot of boards. I speak to a lot of people about this town, but I try to bring the good foot forward. But this is not standing well with me.
let me try to.
Those two things, the plan of action, that's just for me. That's just for me, not for them. That was just for me. The mayor designee, that's us. That's us as a board designating whoever is the partner with you in the town.
But
There
y'all
was no-
always bring
there was
y'all
no-
right to the people that's trying to
There
help
was
y'all.
no, there
Y'all
was
always
no
bring y'all
discrepancy.
garbage.
There
out
was
here.
no argument, Ms. Jordan.
It's
You know
a
what I
man.
did? You know
What?
what I
Just
did
wait,
when
This,
I-
we have to
this
stop.
is,
Now
this
we
is
stop.
just the board designating somebody, that's all.
Well, I
You're
just don't
getting-
want to
you're-
get caught up.
You're
in
not,
politics.
you're
I
not
was
getting
so
caught up.
excited when I saw 5 on 5, because believe it or not, since March, we have not had any 5-on-5 of anything in here. So when we start tearing and breaking things up, you know what happens then? It's gonna be taken.
So I'm trying to hear, are you?
I'm not
against, but
again, if the MOU is what we have to do to go forward, then let's go forward. But what we need to do as a board is everybody that comes up here and wants something from this town, they all need to do the same thing. Same thing.
That's the problem. Don't start it when it comes to us. Y'all start.
If you're gonna do a lien on my property that I paid for, then everybody in here that comes to this town and wants something, we just gotta be fair and transparent, and that's what I always am when I deal.
So we're right there in the memory.
With the memorandum, I spoke to Ms. Williams, and Ms. Williams said she called or checked Sanford, and that's where she got the MOU from. So it's verbatim from whatever Sanford had, so I guess it's what we're supposed to do, but I'm just wondering, because I asked you too, this is the first time that you've had to do it.
Because we never had a welcome center.
Yeah, you've never had a welcome center, but we have other stuff going on.
We never had a Main Street, but you didn't have the MOU for that. But it's just like you wanna start stuff with the chamber, you want the mic, you want to stand up, what I do for you.
Come get mine.
It's a question. Okay, so when you guys start a new thing, it just seems that it falls on the Eatonville chamber. Just like Ms. Wiley stated, nobody had a lien on their property or any of that stuff until the chamber decided that they wanted to do something. And then magnificently, it comes up with a 3-year lien on your property. Okay, same thing with the MOU. I've been sitting with these council meetings all the time. You understand? There has not been an organization that you all have required an MOU from. They partner with y'all, whatever you call it, they take your money, they do everything.
And using that seal wherever they want to use. You
Well,
guys don't even know they're using it,
what-
and they come in here with the paper.
What the paper from last week? Y'all don't, they had the seal on it last week.
With flags, looking
With
like.
flags, you know,
I'm
everything.
sorry. Okay, so let's keep it right.
Okay, you're right. Let's keep it right.
Let's keep it right.
So I sit here and been quiet the entire time for this. And I have had a conversation with the chamber, and I'll be the first to admit that there should be MOU. And granted, you're right, there hasn't been done, but from day one on other organizations coming up here, I have been saying that MOUs need to be in effect. MOUs keep everybody honest.
Has it happened?
No.
Well, I've been shot down every time. And
But
it's
now
supposed
you're
to be-
being shot up.
No,
Don't get brand
no,
new
no,
up.
no, hold on.
You're right.
But let me finish. So, and I understand the passion that's coming out right now. Cause really, if the truth be told, we're mixing two things that's going on right now. And I mean, can we be honest about it?
I'm very much being honest with you.
Right, so we're being honest that it was some taking advantage of with the.
$30,000 that we need to get back, we still don't have on the CRA
And
yet.
hold on.
How can we get that? That's
Hold on, short. And I'm willing to fight that battle with you. I said it from day one. I said it from day one. Let's call it special meeting, but that's a different entity that we need to discuss that out of. That's come out of CRA, not the town council. So, but dealing with the MOU, and I think the biggest thing is wording like Ms. Randolph said, normally when, Councilwoman Randolph, when things are going on, the MOUs are in place to keep everybody copacetic along the way. So, and I think the biggest thing that's come up is who has the designee. Now, I will say you that if I recall that with the other, I'm gonna say the name, with PEC, I'm real. So with PEC, there was the board designated someone to be the liaison between the town and PEC. So I think that's what we're trying to say. I don't know if y'all know that or not, but it's supposed to be somebody supposed to be designated from the town with PEC to go through with planning and all that stuff. So I think maybe what everybody's saying is that we need to come up with a designee that'll work alongside y'all. It ain't that we on top of y'all, we below you, whatever, we're working alongside. And that's
all
the big.
fighting amongst yourself to decide who is it gonna be? Fighting with the mayor. Fighting with the mayor to figure out if y'all gonna have a say, is she gonna have a say?
It's
We
not,
just don't wanna be in your crap.
it's
No,
not, it's
listen,
not a
I
fight.
think based on what Councilman Daniel just said, clear it up for me. When I see the word administer, that's administration. That means if you have an issue or something, you're gonna call town hall. That's under the mayor's auspices. But what it sounds like is you want perhaps Councilwoman Randolph to be your contact. I mean, not you, that's what it sounds like. You want a council person to be the contact.
No, I didn't say that. I
We
didn't say
don't
that.
want y'all to be arguing about who's gonna be
I'm just
over
trying to
it,
get
and
it
then
figured
it
out.
get tabled.
No, I'm just trying to get this
Right.
part. figured
That's
out.
what I'm talking about.
Cause tabling is what you guys are known for.
I come up with
Can I-
solutions.
Wait, no, please. Oh, yes, Councilwoman.
You know, like I say, I deal with Chamber a lot of credit. They do a lot down there. And I would say, in this here memorandum, I don't have anything against anything that's been said. In fact, I was gonna ask the question, is who put this together? Because this may or may not be necessary, but however, I think all the officials, anyone in the town, no matter who you are, can actively engage and be involved in the chamber. It shouldn't have to be that the mayor has to appoint somebody, because that's when the politics starts, right?
Yes.
We're trying to alleviate all this politics that's going on and favoritism that's going on in the town. Everybody should be fair. If Councilman Washington wants to go down there and communicate and get something done, he can go. If the mayor wants to go there, to be fine. All of us should be actively participating anyway. We shouldn't have to designate a person to be the liaison, the communicator, the representative for the town. I should be able to feel free that I can go there and say something or get involved or have an activity or do a partnership. And the mayor shouldn't have to interfere with what I'm doing. I say, hey, I got a designated person to do this. I don't want you doing this because now you're interfering.
And that's
See,
not how I
that's what
understand
I
that at
don't
all.
want, no, that's what I don't want to happen. I had an incident months ago that I was accused of interfering, and I was not interfering. So I'm totally against this particular statement here about the mayor's office. There's too much control and it's overpowering people to feel free. They can go there and communicate with you and be able to do something. Anybody in here should be able to go down there and it shouldn't have to be a designee.
And we do have an open door policy, I can tell you, you know, some come a little bit more often than others. Yes.
No, I was gonna go on with the business, whatever you say,
Yeah.
because if you're saying that if we just strike this, if we strike this right here, then we can just go ahead and vote.
But thank you everyone for listening.
Thank you
I
guys so
know
much.
it's interrupting the flow of the business, but sometimes you can't just sit on it, even though I sit on a lot and just go home with it. But sometimes I think you have to be heard so that people know where you're coming from.
And could you do the correction for this? You said it's not a problem.
We're C6. Yes, Ms. Williams corrected it.
Oh,
And for the record, you received the updated copy of the plan that was handed to you.
okay, that's what was, all right.
And real quick, because some people may know, can you tell them what C6 is?
C6 is basically, the difference in the C6 and the C3 is that you have to use it for marketing. With the C3, you can just give somebody some money and they can do whatever they want to do. But with us, when you donate money to us, you use it and put it like your marketing, as for marketing purposes. So, and we just have a C3 if you want to donate some money, so we'll accept that.
The community building.
All right, so you simply want to strike out of the 1, 2, 3, 4 whereas.
Yeah.
Okay.
All right, so.
If Mr. Warner or either,
But-
Mr. Warner wants to communicate and bring something here to town hall, you all just go ahead and bring it up here.
I don't think that's what that was saying, we'll do it without it.
Don't stress me for trying to do good in the community.
And that's not
You
how I was.
understand what I'm saying? Don't do that. I ain't like, don't steal.
No,
I'm saying we won't do none of that unless you just want to think.
No,
That's not what we do. Everybody in this whole community know that's not what we stand for.
No, I
We do good, reputable business at the Eatonville Chamber of Commerce. I really wish all y'all come through the door so you can see what we do. And not just see me up here, you know, y'all trying to bring my character.
All right.
Thank you.
All right,
I
so
love
you
Eatonville.
Fourth whereas, I was thinking of administration. All right, thank you.
Thank you so much.
So you're good with the plan of action?
Yes.
All right.
We want to work with the town, and if that's what it takes to work with the town, we want to. And after hearing the attorney speak tonight, we realized that a year is probably good for us initially, so that we can work out the kinks and figure out what happens, because I never thought about sunshine laws and all that being with nonprofits, so that's something that we're working on.
All right, I mean, so the, and again, let me be clear on this. When I read that, I simply, if you had a question and you wanted someone in the town to do something, it fell under there. That's how I read that. It had nothing to do with partnering, visiting, stopping anyone else, nothing like that. So, all right, so the motion is been moved and seconded with the amendment of striking the fourth whereas.
Yes.
All in favor? Aye, all opposed? And with that, reports. Ms. Williams, you have a report. Town attorney, you have a report.
The first hour.
Councilman Sanders.
First off, thank everybody for coming out this evening. I hope everyone weathered the storm as best as we could. If anything, this hurricane has taught us that we need to work together and we gotta come together as a community. It's not about I and all those things, but we really have to come together and make things on. Ms. English, can you give us an update on our infrastructure, on how we stand? Are we back at 80%, 90%, 100%? What is it?
Will you please give us an
I think everybody would appreciate this outreach and the rest of the work. Last week was but I would say it's between 12 and 18. Rain and flooding. Catalina, first of all, was expected. The problems that we had with the condition. Catalina itself, I've spent a lot of time out there. Month and a half with the guys, really, asking some questions with county and they, Catalina really controlled by really human. Bring the fish, but it does have an outfall. Appreciate that. That part about it is let's go with that. So when the houses in overall, I like to think guys that work, and you're right, I think we need to put a little bit more, we need to be more prepared to Catalina, particularly, there's some work that can be done to improve that. with water. That coupled with, the fact that our infrastructure, sewer system in particular has rear of, breach. It really could have been a lot worse. Sad part about it is some residents was affected by, situation on the main street and on, with the situation, there's, I think there's 4 houses that have checked that have installed in the lift station here, which alleviated backflow in their houses. But, that, it overflowed the street and still overflowed the street. So, just on the phone with the staff member, we had a vacuum truck out there, they took many loads out just tonight. Let me say this. If we had, those of you that saw it, the manhole floating above the ground, I haven't seen it. And it was, our pipes need a lot of work. We have a lot of work to do. A lot of construction. Go stronger, grants. With the meters, starting with the master plan and some of the other things. Right now, that's very close up from there and water. And, very close to the power outage that was out of Gerald. That affected the water plant, it affected the generator, it affected the plant. Very close to losing that, but work through it. Help the guys and some industry, bring day and others and choices. Work through it and was able to avoid that. So it been catastrophic for us, but you know, not get some water, not having to go for a boil, water. So, I mean, I could just go on and on, but there's a lot of work to be done. I appreciate the patience, and I know, you know, some of the questions, you know, sometimes they wear on me, but really you don't, because I know that you guys care and you want to know what's going on. I get some frustrated sometimes. Days of responding, but the effort is there. I'm very proud of the guys that I do have. That they've done over the last couple of days. Be patient with us and trying to do the best we can.
Deputy Chief, I want to say thank you for providing the opportunity, when the hurricane was lifted enough that we get out. Thank you for giving the opportunity to go out and actually see and just talk with residents. Along that line, because of the flooding that was in Catalina that we've seen on Kennedy and Wymo Road and all that. Do we have a capability already in place for reverse 911, or do we have to go through someone else?
We have to go to the county first.
Okay. And the reason I was asking that, as we see back in Catalina, some people, the water was up 2-3 courses high up to their backyards. So I think it's just important for us to be able to communicate. I've seen other communities do it, but awesome job to your people. From what I've seen, was out there was riding and just good things. Good job on that. And I'm just big on preparedness. We have to be prepared. And I'll just tell you some things I saw. I don't think we had enough barricades, enough cones. And Deputy Chief, we talked about this, that we may need to look at our grant money and start this infrastructure and buying the barricades, because we had trees down, we had power lines down, we had water. I mean, at least 3 or 4 roads were blocked, the water was there. And we had only 1 or 2 cones or 1 or 2 barricades, and I don't think we had enough. So I think that stuff like that got to be prepared and ready to go. From a town standpoint, I think we need to really just communicate things out to our residents. Our biggest thing that I've heard from residents is that they didn't get enough communication from us in reference to sandbags. When the sand was available, it was like last minute. We just got to be preemptive. When we know major storms and stuff coming up, we have to think what we some people not thinking about, hey, I need sandbags, I need to get water and all that. I want to remind everybody that insurance, go through your insurance first, go through FEMA. We need to probably get some kind of leadership on everybody's door that FEMA is available. Orange County is a disaster area, but those are things that need to be communicated. One other thing, Attorney Shepherd phone call you and I had today, I just want to publicly address it. That, Mayor, I would like to know where Ms. Williams is getting paid out of, when it comes down to, CAO, there's no money in the budget, so I would like a written response on that. My last thing is, I've said it for a long time that a delay is not a denial. A delay is not a denial, and you just gotta be persistent and continue to walk through things. So on today's date, my delay that has been happening is not a denial anymore. So on today's date, the Florida 5th District, my appeal is one on my behalf. The judicial system has spoken, and this case is now at a close. I rest.
Councilman.
Yeah, good evening, everyone. I want to, first of all, I want to thank everyone for your condolences and your prayers. I lost my brother. And as most of you all know, I lost my husband about 5 weeks ago. So I want to thank you all very much for your cause and your support and your prayers. Councilman Davis basically covered some of the things I had in my report, but I would like to just kind of put a lot of emphasis on emergency disasters to make sure that we have adequate information in a timely manner to the citizens. I think it was some of the efforts that was done and accomplished was basically the same issues that were other places, Maitland, Orlando, about the sewage issue. And it's only so much that you can do with the type of storm that we've had. I've had an opportunity to better understand exactly how far we were able to go with that. But I think the issue is that's communicating, making sure that we have the signs on both sides of the street. The street down here on Eaton Street has been the really focus of my attention every single day that this happened. I've been there several times today. I've been there to talk to the neighbors and the residents that live in that house there. Actually, the next day, and you can literally see waste and toilet paper coming out of the drain there. And it's just little things out there we can do to improve ongoing communication. From what I can see and I saw, it appears that a lot of the city workers were really out there trying to do what they needed to do. I mean, there's always some areas to improve, but this was probably one of the most unusual storms that we've had. It was a water hurricane rather than a wind hurricane. So I do understand that. Also, someone had brought up about the town logo. I did have that on my sheet. That means to cease and desist. People are using this logo for the town of Eatonville for their own benefit, and we need to make sure that it's approved by one of our departments, either the town clerk or the CEO or someone. No one should be using the town's logo without permission, because that is a copyright issue, and that should not be permitted. So we need to put something in place for that. Also, no one should be using the town's address, either the CRA address or the official town's address, for their own benefit or for their own personal mail. That goes for everyone, including employees. We still have an ongoing case with Mr. Benderson. I spoke to Mrs. Gibson about it. I know we brought it up in the meeting, we brought it up in the other meetings. This issue needs to be resolved. So I'm asking your attorney, you had mentioned Mrs. Gibson about the resolution. If you can get with the attorney, we can settle this thing once and for all. Okay. Also, I have a couple of projects, but right now, due to the roof issues at the Denton Johnson Center, those things are going to be put on place. Was one that the residents would like on their wheels, probate, and also power of attorney. So we do have an organization, the Florida Legacy. We're doing some workshops, but we're going to have to table that. Initially, they sent me a request for November the 2nd. So I'm not gonna bring it back to the council until I know exactly how we're doing with the particular officer. Also, in observance, we're very lax on walk-ins. People are walking in, there's no documentation as to who's here, what time they arrived, or what time they left. So for security, for everyone, including the workers, as far as others coming into our facility, we need to immediately put some security things in place. Mrs. Williams, you think we can get something like that going? To sign in, so we know who's here? Okay, thank you. Other than that, I don't really have anything else. I just want to thank you all. Like I said, I was out there in the trenches with everybody trying to do what I can do, get water, sandbags on my truck. I even offered my truck. Anyone that wants to use my truck to go and get supplies, emergency, or whatever they need to do, I made myself and my property available to have the residents. And I want to thank everybody for doing whatever you did and whatever you could do to try to help the town. Thank you very much. Have a wonderful day.
I think about coming up this evening. I think this storm was a historic storm for a lot of cities. Some cities still going through it. That's the only kind of Geneva, part of the sewer still coming up. I came here, he was talking about, they don't know when it's gonna stop from the water to sea, stop this sewer, it's overflow. That's what happened. It's water. They go in our system and it bubbles up where it will come out. Where the sewer, manhole cover, that's where they come out. So we just have to wait, you know, these things, I know, these things in the department doing the best they could with that, but that's the nature. So we're not gonna be able to stop. I'm out prepared for another storm after last one we had. This way for that y'all go like a beach. I mean, that happening last. So I think that y'all look like the ladies who make that. I mean, this happens. This will happen another storm. You can't prepare for this. You just have to be ready for it. You have to be ready for it. That was the first you do. It's gonna be it's coming. It's gonna happen. But the water's gonna come. But we're lucky. We're not like, you know, take a boat to get to our house. Some places you have to take a boat to get to our house. So these days, we're going to see that in St. John. Yeah. So let's thank God that our citizens, you know, don't have to do that. Take a boat to get from 24 feet. Another thing, I want to thank the staff, thank you about out there. I go around and see like, why did she still down in the water? That's like power line. I'm like, that's the reason we couldn't touch the tree. You know, on my sister's house, the tree filled up for God. They do it to the good power. So, like I said, these things happen. You know, we just have to put them on nature. And like I said, these storms, the trees that we can take care of, we can look at. That's what we look at. That's what we look at. Stop some of these dead trees falling. Ones that we wait not to get probably fall to. So I think we're about being safe, you know, but the storms.
Good evening, everyone. Be brief. Ms. Wilder, Ms. Jordan, Ms. NY Theory, Macedonia, Open Door. Thank everyone that has ever talked to me and has heard me say partnership. So up here tonight, it was more just of administrative thing. But I think we have all come to the conclusion that we can only go forward by getting them all together, by partnering. I said that EKO, University of Kings and Queens Motorcycle Club, if you want to get somewhere in the top here, you got to partner together. I don't think anyone up here would have a problem with the Welcome Center or SORA. You know, when we're partnering together, when we're working together, when we understand what your goal is, your ultimate goal is to bring Eatonville and put it on the map. I think that's with any organization, even the churches here, Macedonia, Open Door, Life Center, Redeem and Life. We're all here to partner and work together. So I hope that our MOU wasn't taken out of context. We really care. We really want to welcome center. We're trying to go to the next level. Please don't take it personal. We are here for you and to help you succeed in whatever you're trying to do. and we're gonna work on getting your $30,000 back. Also, I think we are blessed. Those flood, I don't like hurricanes. People have went out, and I'm scared. I would stay in the crib until I get the okay, because I don't know if the streets are flooding. I don't know if it's a sinkhole, if my truck broke, and I got a little lift on my truck. Y'all ride my car, I'll wait till Tom Terry says it's okay for me to go out, and then I'll go get in my truck and try to ride around the scene. Flooding, we have to be more creative. I just think outside the box. With a hurricane coming, do we drain that lake behind Kempton Park? Do we have the resources to drain it a little bit just to prepare for that? I'm just thinking outside the box. Having your own self to be prepared, that you have enough water, so that you peanut butter and jelly, stuff like that. You gotta be prepared yourself. A lot of this stuff has been covered by the board. That's why I'm not going to take up too much of your time. Communication. I think I've gotten a lot of calls from people saying I didn't know that the boil water alert was lifted a long time ago, and it has. I think we as a town, as administration, have to get better on, getting this information out, because a lot of people are not on the phone tree. So maybe we have to get those labor pool people to get out and walk and maybe hit some doors and stuff. The former mayor Cole really enlightened me on some things, when he stood up and spoke about the grant. And I have those questions too. Like Ms. Gibson, what is Ms. Gibson here? She's gone. Ms. Gibson, I have a question for you. I have a question for you. Out of that 1.5, we've gotten 550,000. 30 for the water tower, 300,000 for the water tower, 200 for the meter replacement, and 50 for the valve replacement. Where that? The former mayor had a point. Where's that other 5? When are we still in line to get it? You can come on up. I'm asking because I thought about it. I was wondering.
The other half of the money is in the bank. We received it maybe 3 weeks ago.
Okay.
And we haven't decided yet what we're going to do. The public work is working on that. To say what infrastructure we're going to work on that. We did receive 6.5 for Lake Bubba and Marine, and then whatever 5.9 is going to do. So, as I know, on top of his list, we talked about it. He's ready to get this bad situation taken care of. That's the first part of it.
So now let me ask you, and Mr. English, if not, ask the mayor, can you come up? Okay. If you come up, I just got a question for you, and I won't be long, y'all. I won't take long. So,
You don't say it's there, and it
Right.
will be come back to council, say what we're going to do with it.
right.
We receive it at the time.
All right. So this is for Mr. English. So we don't have a water valve replacement plan in place.
No, we don't. Yes. Water valve, the valves over control of water. I talked somewhat to the engineers about how we go about replacing the valve. Have to shut the water system down, replace the valve. That would be the problem. We would have to shut water down to
Right. I think we do. I think you had 50,000 that was designated for that last year, if I'm not mistaken. Now, my next question here, then I'll be done and everybody can go home. When we have a water break like we did on the Calhoun, if we don't know where the water turn on valves are, is it feasible to put one there and then we'll mark a new map saying this is where this one is?
Well, you really want to put them at junction points. It changes the direction, right? And intersection where the water system changes direction towards the intersection more forward.
Okay, thank you. And I just, thank you, sir. Yeah, I just don't want to hold people up. Thank you so much. As usual, thank you guys for coming. Don't forget about Ray James. Won't forget about Michelle Cole, and I won't forget about Conference Freeman. I won't forget about the investigation of James. Have a good night.
I really, thank you, Attorney Shepherd, and I really came with a praise on this today because I thought that preparation went through the best practices for INCOM to be prepared for the storm. And some of the stuff that the public works department had to deal with, there was no way to know that much water causes so much damage. but I do, full appreciation to Public Works, Mr. English, you really worked hard. So thank you and all the rest of the guys in Public Works. Attorney Shepherd, I had a question. Did you get anywhere with the sewer and water connection fee issue? Is that not something to discuss? Right?
When you say get it, what do you mean?
The possibility of the town having to waive fees.
Having to, are we talking now about civic development agreement?
Yes.
Oh, I've talked to the attorney and said, we're not waiving, and because it's not our fees, the pass-through fee that goes out on the street. I told them,
That was one, there are 2 more sets for the sewer and water as well.
anything that's not our fee, I've taken the position, it's not waived by that agreement. Now, could that agreement have been better drafted to cover that point specifically? It could have been, but at least for now, I haven't gotten any pushback. I got an actual email from her wanting clarification on certain fees, whether we're talking about the same one or not. What I will need to do is get with, I don't know, Mr. English or someone, maybe Ms. Williams, someone to say which fees are pass-throughs that we don't get anything, but we have to collect them because it's not something we provide. And make sure. But the agreement is pretty comprehensive about our own fees.
Right.
And
Those
so
are the concerns.
that's the issue. But I had that conversation with her literally as the hurricane was hitting us,
Okay.
because they were very anxious to get stuff done, before Thursday.
Because it's gonna be hard to fix pipes and all of that if we have to.
Oh,
waive
I
those kinds of fees.
and if we have to bat over that, I'll fight it. I don't think we're gonna have to though.
Okay, I hope. Shane,
Where are we on impact fees?
and that is a good question for impact fees. We do have a study going on. We still have all the documentation. But we'll have to follow up with you on that. Chamber of Commerce. I do appreciate you. And sometimes what you think is what's not true. See, I think, and just for I know you brought up the issue about the baking and all that. Mr. English and I did talk that for Catalina in general, fix this by those, we do need a civil engineer to come out here and to help us understand what the full fix would be. Not just fix this because that's what's broken out. And I think that's what's been happening in the past, is that we've just been fixing here and there, but to have a comprehensive approach to a bigger fix for Catalina. It may not fix it all, but it'll be something that's long lasting. Because running out there with a pump for every storm, that can't be. So and we did talk about now that we're getting out of the rainy season to pump out Lake King. We've had that discussion as well, but again, we discussed several things, but we do need to come to a remedy about that and the pipes. And I miss Whitman. I heard you, and I think that is it. So with all being said, I move that we adjourn. Second is moved and seconded, all in favor, say aye.
Yeah. That's your next time.
All right.